Welcome to An Ounce of Prevention, the podcast. At Reese Associates, we believe that an ounce of prevention is worth a pound of cure. Our daily commitment lies in informing our clients about legal risks without hindering their business objectives. As we like to say, we're in the business of building companies and helping executives sleep at night. So stay tuned. Maybe you'll learn something that'll help your business grow and thrive.
Welcome to An Ounce of Prevention, where we believe an ounce of prevention is worth a pound of cure. I'm your host today, Kaysha Spoon. Before we get to our discussion, let's take a minute for our case law update.
Today we're discussing Byers Peak Properties versus Byers Peak Land and Cattle, LLC, a recent decision from the Supreme Court of Colorado that addresses whether Colorado's statutory waste of water provisions can be enforced by private landowners and what happens to the related trespass and nuisance claims when the statutory theory fails. Here's what happened. A Colorado ranch was divided into two parcels in the 1970s, an East Ranch and a West Ranch. After the split, the parties continued sharing irrigation infrastructure, including two ditches, and each granted each other easements for water conveyance. Over time, cooperation for the irrigation deteriorated. The owners of the East Ranch alleged that the West Ranch owner was diverting more water than it was entitled to use. According to the plaintiffs, the excess diversion caused irrigation runoff and flooding on their property. The East Ranch owner filed suit in Water Court Division 5, asserting several claims, including a declaration of waste under Colorado law, a statutory claim, along with trespass, nuisance, and requests for injunctive relief. The Colorado Water Court ruled largely in the plaintiff's favor. It found that the defendant had diverted excess water, violated the waste statute, and caused flooding. The court awarded nominal damages, granted attorney's fees, and entered an operational injunction restricting the defendant's ability to divert water in excess of its decreed rights. The defendant appealed. The key issue before the Colorado Supreme Court was whether the plaintiffs even had standing to bring a statutory waste claim in the first place, and whether those statutes create a private right of action. The court held they do not. First, the court explained that the Colorado statute regarding water waste contains its own enforcement mechanism. Violations are prosecuted in the name of the state. Because the legislature provided a specific public remedy, courts will not imply a private one. As a result, the plaintiffs lack standing to seek a declaration of waste under that statute. Second, the court held that the Colorado statute does not apply to flooding damage caused by irrigation runoff. The provisions in question are aimed at protecting water rights from over-appropriation, not compensating neighboring landowners for surface water impacts. That meant the statutory claims failed, and the award of attorney's fees could not stand either. Once those statutory claims were out, the jurisdictional structure changed. Water courts have exclusive jurisdiction over water matters. But here, without a viable statutory water claim, there was no remaining water matter tied to the alleged waste and flooding. The court concluded that the water court lacked ancillary jurisdiction over the related trespass and nuisance claims. Because the underlying claims failed, the operational injunction fell with them. So why does this matter? First, Colorado's waste statute is not a private enforcement tool. If you represent a landowner dealing with irrigation runoff, you cannot simply plead the specific statute and assume you're in business. And second, not every dispute involving water belongs in water court. If the claim is really about property damage, rather than the right to use water, it may belong in district court. That's it for this case law update. I'd like to thank Jacob Wilson, an associate in our Denver office, for his help on this update.
In my work as a title exam specialist, I see how careful title work gives operators peace of mind by helping them get ahead of issues and proactively curing defects. On the flip side, we all know mistakes in ownership or leasing can cause huge headaches later down the road. Our job as title attorneys is to eliminate that liability as much as possible. Today, I want to walk through how we approach title work at RR&A and share some of the systems that we've put in place to, yes, make sure our ownership and our recommendations are accurate for the client. But that's the bare minimum. Our goal is always to make our opinions as usable and as relevant as possible for each client. First, we have checks in place to prevent simple human mistakes. Even small rounding errors can create problems for clients later when revenue is distributed. That's why we have checks in place to carefully verify every formula and every DOI before the opinion is finalized and then sent out the door. It's a small but a hugely important step. We also look for small technical things a lot of other examiners might gloss over. For example, yes, this lease allows for pooling, but does it require a unit declaration be recorded in the county or mailed to the lessors to be effective? These are the little details that we as title attorneys have to be picking up on and then pointing out to the client. We also want our opinions to be practical and usable for the client. Not every defect carries the same risk. Some represent a genuine threat to ownership or operations and need to be addressed immediately before the client leases or drills. These high-risk defects are the kinds of things that we're communicating to the client even during an exam. This gives them the opportunity to start curing the issue as early as possible, instead of reading about it in the title opinion weeks later. Other defects are more technical. They exist in the record, but because of the passage of time, they don't really represent meaningful risks to the client's interests, and they may not even be possible to cure. So we differentiate between these low and high-risk defects, which can vary even between different clients based on their risk tolerance. Some clients prefer to cure every issue in the record. Others focus primarily on defects that present a clear operational or ownership concern. So we set out the risk level clearly so our clients have a full understanding, and then they can prioritize the defects that matter most to their operations. To further help make our product more usable, we provide supporting materials along with the written opinion. For example, we submit flowcharts that visually map the chain of title. There's full transparency in how we've credited interests from one party to the next to reach ownership, which is useful for curative work, and eventually for the next reviewer on supplemental opinions to understand how the title developed without completely retracing the entire chain themselves. We also want to do all of this with maximum efficiency, both because title projects can often come with short deadlines, but also because we want our work to be a good value for the cost for our clients. Our examiners are skilled at doing quick, independent research. If we can solve a defect with 15 minutes of effort, whether that's fixing a gap or finding a missing estate, then we avoid billing the client to draft a long summary requirement explaining what the issue is, and the client saves time and money on doing their curative work. Finally, we tailor the format of our opinions to the client's workflow. Traditionally, title opinions are drafted in Word, which works well for many clients. But we also offer Excel-based opinions so that the entire product is drafted in Excel. This allows requirements to be sortable by risk, stage, or other categories, and lets us add internal note columns so the client can track their curative progress. This really turns the opinion into a practical, working document that can be used by multiple teams within the client's organization. Our goal is always for our final product to be as user-friendly for the client as possible. Title examination may not always be visible, but it plays a critical role in protecting the client's assets and preventing problems before they arise. At RR&A, our process is designed to be careful, transparent, and practical for the teams that rely on the opinion. Thanks for listening, and we'll see you next time.
When you hear Reese Associates, you probably think of a firm that brings value, insight, and service to the Texas oil and gas industry. You wouldn't be wrong in that assumption, but the reality is our expertise extends far beyond a single industry or state line. Energy is where we built our foundation. We've spent years serving operators, non-ops, mineral owners, and energy-adjacent businesses across the U.S., but our work doesn't stop at the wellhead. Today, it extends to renewables, water management, and energy tech. It supports companies as they scale, restructure, raise capital, or navigate mergers and acquisitions. And beyond energy, we work with manufacturing and industrial clients both domestically and internationally. Our expertise spans the full spectrum of business challenges, contracts, corporate governance, private fund formation, SEC compliance, and complex debt and restructuring. As those businesses evolve, so does our role. And this year, we've expanded again. RR&A now offers commercial real estate practice led by our Dallas office, and a dedicated estate planning practice headed up by our Denver team. These additions reflect how we think about client needs, because they don't exist in silos, but span industries, borders, and all stages of growth. So if you assumed RR&A was just a Texas oil and gas firm, think again. We're business-minded attorneys first, with the experience and perspective to support companies and industries across the globe, wherever they grow. To explore what RR&A can do for you, send us an email at podcast@rreeselaw.com.
The information and material in this episode is general information about our practice and firm and is for educational and informational purposes only. This information does not offer specific legal advice, and the use of this information does not create an attorney-client relationship with RR&A or any of its attorneys. The information in this episode, or any episode of An Ounce of Prevention, should not be considered legal advice, and persons should not act upon this information without first engaging professional legal counsel.
Thank you for listening to An Ounce of Prevention, presented by Reese Associates. If you found this episode informative, subscribe to, rate, and review our podcast on Spotify, Apple Podcasts, YouTube, or wherever you listen to stay up to date with future episodes, case law updates, and breaking news. If you have any questions or are interested in learning what RR&A's outsourced legal department can do for your company, reach out to us at podcast@rreeselaw.com. That's podcast@rreeselaw.com. law.law.com. Follow us on LinkedIn or call 832-831-2289.